All right, good afternoon, everyone. Welcome to the beginning of the 2024 hearings in ED&A. We're going to start with doing the pledge, if you would join us. Senator Perkins Quilker will lead us. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We're doing 369.
We are. Well, welcome everyone. It's very warm in here today, so we've opened up some windows. If you get cool, we can put them back down, or if you're still too hot, feel free to let us know. We'll open them up a little more. All right, we're going to open up our first hearing, Senate Bill 369, and I will recognize Senator Carson to introduce the bill.
Thank you, Mr. Chair, and good afternoon and Happy New Year to my fellow committee members. It's a pleasure to be back working with all of you. I hope you all had a wonderful holiday season. Mr. Chairman, for the record, my name is Sharon Carson, and I have the pleasure of representing Senate District 14, comprising the towns of Auburn, Londonderry, and Hudson. And I have for your consideration this afternoon Senate Bill 369 FNA, which is directing the Office of Professional Licensure and Certification to provide notice of public meetings and an opportunity for comment, creating a new position and making an appropriation therefore. Mr. Chairman, this bill should be very familiar to this committee. It came through our committee. We supported it. Unfortunately, the governor vetoed it, and I argued vehemently on the floor about how important this bill was, especially in communicating with the boards, how important that is. But unfortunately, the veto was sustained, and so we need to move on. So I filed the same bill with the recommendations from the governor's office, and I'm hoping that we can pass this, and the governor's office is going to be okay with this, and we can create that mechanism, Mr. Chair, that quite frankly really needs to be in place. There is an amendment because unfortunately a piece of it was left out. So, but our esteemed chair is going to be presenting that amendment. So I'm going to stop talking and say thank you all very much. And again, it's a pleasure to see you all.
Thank you, Senator Carson. Any questions before we move on? Okay. Yes. Just a reminder to the committee, if you're going to speak, to turn your mics on so we can be heard. All right. If
I may, Senator, I think we're going to be OPLC for quite a bit. So
there are quite a few bills.
Yes.
OPLC. All right. Thank you. So the amendment that Senator Carson referred to is amendment number 2024-0048S. You should have it on your desks. And what I'd like to do is I'd like to bring Director Courtney. Is Doug with you too? No? Okay. I'd like to bring Director Courtney up to just kind of come up and talk about the changes that the amendment does, because this is some language that we agreed upon. Okay. That we agreed upon with the governor's office and with the OPLC director, so that we could find consensus and fix the issues that the governor had in the veto. So if you'd like to come up.
Chair, I have two amendments, so I wonder.
Yeah, it's going to be the one 0048S. Kevin, do we have extra copies in case folks in the crowd would like some in the audience? And by the way, before we go on, I want to welcome Kevin back. He's kind of taken over as our committee aide here, and we appreciate your work. And thank you. Look forward to having a good, solid year with you, and we'll thank you in advance for all the grief we're going to give you. Senator Altshuler. 337?
Correct.
Yeah. Yes, that was last year's. All right, Director Courtney, if you'd like to walk us through the changes in here, and by the way, welcome.
Thank you. Happy to be here. Thank you, Mr. Chair. I'm glad to see you kicking it off with OPLC this year. Lindsay Courtney, Executive Director, Office of Professional Licensure and Certification. So before you, Amendment 2024-0048S, there are really two primary differences between the amendment and the original language in Senate Bill 369. The first is that under Roman numeral 4, line 7, it allows the board a little bit of discretion if there are issues that arise that do not constitute an emergency under 541A, but require immediate attention. It allows them to convene a meeting without adhering to the 14-day notice requirement. We often see this come up in cases where there's a unique application issue. Somebody needs to get licensed. The office isn't clear as to how to handle it because it's a unique circumstance. We don't want to have to wait 2 weeks unnecessarily so to convene a meeting. And so this amendment allows that flexibility. The discretion lies with the chair to make sure that a meeting is absolutely necessary in order to meet public business. So that's the difference. That's the first difference. The second difference is it starts in line 20 in terms of what happens in those circumstances in which materials, there's a late addition to the agenda and the item is not available or publicly available as is, the intention surrounding the original bill. Under the amendment, in such circumstances, materials associated with the new agenda item shall be made available to the public within 7 calendar days, or in accordance with 91A. And I think that was intended to make clear that the office has to undertake the legal review within 7 days and not just let it continue to go on and on and on. And it was intended to increase transparency by making that amendment. With that, the office thanks Senator Carson for the hard work on this, as well as for the addition of the Attorney 2 position that will help us operationalize this, and we support the overall objective, which is to make our operations more transparent. Happy to answer any questions.
Thank you. I think there's one other change that we made as well. In Section 6, we removed the terminology licensing proceedings conducted pursuant to RSA 31011. We removed that in 6. I apologize. In 6 and in 8.
Correct. You're correct, Senator.
Okay.
Thank you.
And the reason we did that, if you want to explain Doug's reasoning for that?
Yeah, the reasoning for that is it's not really it's not really necessary. It was somewhat redundant to have the licensing proceedings within the language. We wouldn't typically release licensing records if specifically requested. But in conversations with the stakeholders, it became clear that they're not really looking for licensing application materials. They're really looking for other documents. And so that's why we felt it was pertinent to remove the licensing proceedings.
Questions from the committee? Director, you'll be here for a bit, right? If somebody
I'm
does come
here
up
all
with me.
afternoon.
All right.
Thank you.
All right, thank you. Rep. Will Infantine, did you want to speak?
I'm sorry, I was talking something. Did you recognize me?
Yes.
My apologies.
That's okay. I know you guys are in the House session today, so I want to get you right out as quick as I can.
Thank you. I will be brief because I do have to go upstairs. Representative Will Infantine. I'm also the Vice Chairman of the Electricians Board. And I can't speak for every board because they're all very indifferent as to the public, what they want, their interest in the committees are and what have you. But I know on the Electricians Board it is important. People are actively involved, and it is important to see the agenda and to be notified ahead of time. And I am in support of this bill. I'm glad. I don't like coming here to testify against OPLZ, so I'm glad to see the amendments seem to resolve any of the differences. So I do support this, and I hope you would all as well.
Thank you. Any questions? Seeing none?
Thank you,
Good
Senator.
luck with the rest of your day.
Thank you.
Bill Trombley. So I don't know what PFGF is, but I know what HVAC is.
Thank you, Chairman. My name is Bill Trombley. I'm the owner of Bill Trombley Plumbing Heating out of Manchester. I'm also representing PFGF, which is Plumbers, Gas Fitters, and HVAC Association of New Hampshire, and I'll try to keep it, I'm going to keep it brief because I know you have a full schedule. We're actually in favor of this bill. Many of our members follow along with the board meetings, and in the past it's been difficult, and we're glad to see this bill here, and we're in fully support of this bill. So I just want to keep it brief.
Thank you. Any questions? Seeing none? Steve Rancourt. Welcome back.
Happy New Year to everybody, committee members. My name is Steve Reincourt, licensed electrician, and also here representing the ECBA, the Electrical Contractors Business Association. We're definitely in favor of this bill moving forward. I was wondering if the committee chair could just point out a couple of those changes. I was trying to follow them quick.
Sure.
As far as
So do you have the amendment in front of you?
yes.
Okay, so it'd be line 7 and 8. There's a little, that was additional language. And then beginning on line 21 with the word within, all the way to the end of the sentence on line 23, within 7 days of the public meeting. That is new language that we negotiated with OPLC and with the governor's office that they could support.
So if I may, Mr. Chair, is that mostly to do with materials being posted 7 days ahead, not necessarily the meeting, it's 14 days, is that correct?
Yes, essentially, it's how quickly, this will guarantee that the review is done, the legal review of any materials. This would only really take place as if there was a late agenda item added that hadn't had a chance to get legal review before the meeting. And that's really what that would pertain to. And this makes sure and puts some parameters around so that OPLC knows within 7 calendar days, they have to have that legal review done, and then that information can be made available.
Okay, so on line 22, it says, public meeting or in accordance with RSA 91A. Is that different? I don't have 91A in front of me. Well, I do, but is that give them a way to not do it?
No, it doesn't, actually. We had a lengthy discussion in my office yesterday with the director and the legal counsel, and no, it does not do that, because I wouldn't have been acceptable with that myself. So Director, I'm going to try and explain this, and if I screw it up, I want you to come back. Essentially what it does is the 7 calendar days guarantees that legal review will be done. The 91A requirement is that they have to respond within 5 days, but you will have some confidence in knowing that within those 7 calendar days, the legal review is done, and their response then should be, we'll get these information right to you. They still have the 5-day response time, because you have to still request under 91A in order to get the documents.
Okay.
Did I do okay?
Yes, correct.
All right.
So when it speaks about, I think it talked about emergency meetings as well, and given that, is it just that part of it for emergency meetings, or does it also give some leeway? Does rule changes and rule hearings become emergency meetings? You know, come to some of the standard stuff that's required by JLCAR, does that fall into that?
Director, do you want to take that question? If you'd like to, you could just grab this other mic right over here if you want to.
But you can sit next to me.
Sure. If you want to just answer that, just in case there's a couple more questions that I can't answer.
Thank you. Yeah, so there are provisions in which there could be emergency rules, but that would be for true emergencies that would meet the definition under 541A29, and under those circumstances, the board can convene an emergency meeting, they adopt it, and the rule is effective upon filing without regard to what happens with JLCAR. In all other circumstances, you have to comply with the typical notice requirements under traditional rulemaking, and you wouldn't be able to undercut those notice requirements using this bill.
And are there any requirements for the emergency notification, or is it 24 hours? Is there any requirements in RSA for emergency, or it can be,
No, I mean, so
just asking, I didn't.
91A requires you to comply with the posting obligations, the notice obligations, but what is not required is that you give 24 hours notice, which is typically required under 91A. And the justification is that it's such an emergency that the public benefit in posting and having notification is outweighed by the board's needing to act. And we typically see that we've done some emergency rulemaking with respect to workforce issues. I recently did one in the agency where we inadvertently increased a fee that we didn't intend to do, and it would have resulted in $600,000 worth of a loss to licensees. So we did that. We didn't think it was necessary to wait the 24 hours. The other instances are when there's true emergencies like, physician diverting fentanyl and that sort of thing.
So just, an emergency meeting can be done when less than 24 hours notice is.
Correct.
Okay, thank you. All right, thanks. Okay. Thank you very much. Thank you, Mr. Chair. We appreciate it. We do support this. I know that the executive director is working hard to fix it, but there's been a lot of issues, meetings not posted properly, stuff like that, and we hope this will address it and give it some time. So we thank you for your time.
Thank you. Any questions? Seeing none. Thank you. That is the last person I have on the list. Is there anybody else that would like to testify on 369 before I close the hearing? All right. Seeing none, I'm going to take a motion to go into exec session.
So moved. Second.
So I'm going to exec this bill right now and get it out of here. Anybody want to make a motion? Or you want me to?
Mr. Chair, I move to pass on Senate Bill 369.
I'll second.
Moved and seconded. Senator Carson moves. Senator Gendro seconds. Gosh, I got to brush up on my process now. We have to
Introduce the amendment.
vote on this before we receive the amendment, or do we? No, we receive the amendment first. That's right.
We have a motion.
Sorry, it's been a little while. I'm rusty. All right, I would like to move amendment 2024-0048S.
Second.
Seconded, Senator Perkins Cloak? Okay, Senator Perkins Cloak for seconds. I worked hard on getting this language and finding a spot where we could solve the concerns that the governor's office had and the director of OPLC, so that we can move forward with this bill, because as we have heard and as we know from last year's proceedings, this is very important to get this notification out and get the transparency that needs to occur in government, so especially within the OPLC hearings. So I feel that this amendment strikes that balance and finds a spot where we can move forward and have this time be successful in getting some language passed and into the statute. Further comments from the committee? Senator Perkins Cloak.
Yeah, just briefly, I just wanted to thank you guys for your work on this, because the concern I had with the last version was that materials, there was no time frame for them to become available if they weren't available prior. So I appreciate the 7 calendar days being added in.
Further comments? Seeing none, all those in favor of the amendment 2024-0048S signify by saying aye.
Aye.
Any opposed? All right, now we have Senator Carson had moved OTPA on 369 with amendment 2024-0048S. Any further discussion? Seeing none, all in favor? Aye.
Aye.
Any opposed? You want to take this out, or you want
I
me
will
to?
take this one.
All right, Senator Carson, now we should be able to put this on consent, right?
Yes, Mr. Chair, I'll move consent.
Second? All in favor?
Aye.
Motion to come out of exec?
So moved.
Second.
All in favor?
Aye.
Thank you, everyone.
Did we say Senator Carson's taking it out?
Senator
Yes.
Carson is taking it up.
Great. Okay.
Next up will be, grab the right sheet of paper here. Are you ready?
I'm ready.
All right, we'll open the hearing on Senate Bill 337, and I will recognize Senator Perkins Cloak to introduce the bill.
Good afternoon, Chairman and members of the committee. I am standing in for my good friend Senator Whitley on this one because she has 2 concurrent bill introductions in another committee. So, good morning, everyone. For the record, my name is Senator Rebecca Perkins Cloak. I serve District 21, which is Portsmouth and the surrounding communities. Today I'm introducing SB 337, which contains technical portions from New Hampshire Momnibus, SB 175, that we inadvertently left out when we placed that bill into HB 2 last year. These fixes were brought to our attention by Medicaid Director Henry Lippman, and so we want to make sure that we can reimburse our providers of doula services in the state under the policy intention of Momnibus, and so we want to make sure that we make this bill a quick fix. as we worked on last year, nothing requires existing doulas to obtain certification unless they want to begin billing Medicaid. And so in the bipartisan spirit of this bill, we hope that you guys can support putting this fix into law. I'm happy to take any questions, but I am likely to defer the technical pieces to those that are here behind me.
Any questions? All right, seeing none, thank you.
Thank you very much.
Senator Risciardi, is she still here? She is, all right. Welcome.
Good afternoon, everyone.
Turn your mic on, please. Thank you. Welcome to EDNA.
Thank you. For the record, Denise Risciardi, State Senator for District 9. I'm happy to co-sponsor this bill because access to lactation services for all new mothers, regardless of their income, is critical to long-term health of the children. The breastfeeding produces significant health benefits for breastfeeding families and cost savings for the healthcare system. A key strategy to increasing breastfeeding rates is increasing access to services of lactation service and support professionals. I know there's been a push to reduce the number of professional certifications and licensures, but the area of lactation service professionals is a very worthy exception. I believe professional licensure and certification should be as inclusive as possible. This ensures those who are qualified to provide a specific service do not face barriers to employment or are not put at a competitive disadvantage. My concern with Senate Bill 337 as written is that it would exclude a large number of lactation service providers in New Hampshire because the bill lists only one specific credentialing entity. For example, the Academy of Lactation Policy and Practice Providers, credentialing over 200 lactation service providers in New Hampshire, which is more than any other such credentialing organization. My concern is by not allowing these professionals to be eligible to be reimbursed by Medicaid, there will be significantly less access to qualified professionals for this group most in need of access to lactation support services. Moreover, because only a small percentage of ALPP certified professionals are currently covered for reimbursement by Medicaid, this will put ALPP certified lactation counselors, advanced lactation consultants, and advanced nurse lactation consultant at a competitive disadvantage. The healthcare industry is facing workforce shortages everywhere, as we all know. Access to lactation support services is so important for new moms. I hope that Senator Whitley and others will be willing to work with me on this amendment to ensure those credentialed by certification body that is accredited by a national or international accrediting agency are eligible for certification in New Hampshire. So this is, to what Senator Perkins Cloca said, this is an adjustment that is a quick fix that we need to adjust what we did in the Momnibus bill, Senate Bill 175.
Thank you, Senator. Do you have a copy of your testimony that we
Yes.
could have so we can make sure we're addressing this? That would be great. Thank you.
Okay?
Questions from the committee? Seeing none, thank you.
Thank you. Have a good afternoon.
You as well. Henry Lippman. Good afternoon and welcome back.
Thank you. Happy New Year to all. For the record, Henry Lippman, the state's Medicaid director. I'll try to focus in, not cover what's already been covered. What actually happened in the bill when it was moved into HB2, it said to create rules under OPLC, but it left out the section in the OPLC RSA. So it's saying create the rules, but then when Courtney looked at it, I don't have that section in law. So that's what is trying to be fixed there. In terms of what Senator spoke before me, in both these instances, I think the emphasis, this is voluntary, and the reason to allow people in Medicaid to be served, the federal requirement is that there be either a certification or licensure that's granted by the OPLC or equivalent in different states that allow someone to be able to bill and be paid for Medicaid. So it's not like we're wanting to do this, but we're to allow people on Medicaid to be served and to have those providers paid. We need this to be there. Could make a suggestion with respect to the rulemaking process in terms of you may hear from a number of different parties that have different options for certifications. That could be worked out with maybe your direction in rulemaking in terms of the appropriate ones, as opposed to trying to get every single one that may or may not come up now. I think both these pieces are very important to providing the continuum, particularly for new moms, and I'm hoping that you'll support it. And it was, I think, the intent as passed in HB2 to do so. Thank you. Take any questions.
Thank you, Director. So once, if we get this bill passed, and assuming it passes through the House, what would be the typical time frame do you think that it would take to get through rulemaking before we could start seeing the dual community be able to access the program?
So originally in HB2, it called for July 124 the creation of the program. I think if this is an early bill, we could start to work on, and there's a sense that this is going to pass informally. I think we could start to work on rules and get the discussion going, and then once it's passed into law, we'll have a sort of a running head start to getting it in. But typically, to get through GELCAR is a 6-month process when you're doing a good job in terms of connecting with all the technical requirements of a new rule.
So it would be reasonable to think that by year's end, we should be able to have the
That would
program
be-
stood up and in place?
That would be my goal, yes.
Great, thank you. Senator Perkins-Coker.
Thank you, Director, and thanks for being here. I just want to follow up on something you said. Are you suggesting that it might be possible that these other lactation providers could be included in the Medicaid certification via rulemaking, or do we need to make an amendment to this bill as proposed?
So I'm suggesting that you could, rather than trying to work through all the different ones that might come up,
Yeah.
just have that happen in the rulemaking process, but you could add something in here to say that, in the interest of expanding workforce.
Yeah.
I will point out one thing, for example, that there are folks in the WIC program, right, who serve all individuals. What we want to be careful is that we not supplant state funds that the feds will cover.
Sure.
I think
Okay.
that's the only issue I have a concern with is, but I think in terms of expanding the workforce and recognizing different levels of competency, and this is not an issue for the department, it's, I think, trying to make sure that, the certification matches what service they're going to provide.
Got it.
Senator, would you be willing to work with Senator Perkins-Coker on getting
Absolutely.
some language that could work for an amendment for this?
Absolutely.
You'd be okay? I'll help you too if you
Absolutely.
need it.
Yeah, totally.
Awesome. Thank
Thank
you
you.
so much. Okay. Ellie, I'm sorry, I don't get the last name. Mulpeter?
Yeah, Mulpeter. That's perfectly fine. Thank you. Thank you, Chair Pearl, Vice Chair Carson, and members of the committee for the opportunity to be here today. My name is Ellie Mulpeter, and I am the director of the Academy of Lactation Policy and Practice, which is the certification body for the Certified Lactation Counselor, or CLC. And I have submitted written testimony already today in a neutral position, so I'm just going to kind of add on to things that haven't been said yet. I know Senator Whitley isn't here, but I would really like to thank her for sponsoring this legislation and advocating for increased access and equity in the field of women's health and family health. All of her efforts really support that. Our mission is to promote evidence-based knowledge and clinical competencies of lactation professionals. As of today, there are 221 CLCs providing lactation care and support here in New Hampshire, making CLCs the largest group of lactation support providers in the state. We know, as has been said before, that empirical research demonstrates that support from lactation care professionals increases both breastfeeding initiation and continuation rates. At its core, we do support the underlying goals of SB 337, which would improve access to breastfeeding support by providing a certification process for doulas and lactation care providers known as IBCLCs to be able to bill Medicaid. While we are aware that CLCs who work for the WIC program are already reimbursed for such services, we are advocating today for the inclusion of all the other CLCs in New Hampshire who work in other settings, including in their own private practices. Accordingly, we are here to request that the scope of S337 be expanded to include all CLCs in New Hampshire, as they all deserve to work and earn a living in their field of specialization, and families do deserve to choose from a wide variety of lactation support professionals. I do have language available and drafted for an amendment. We have had success in other states with a very similar piece of legislation, most recently in New York, and I'm available to the committee if you have any questions. Thank you.
Will certainly provide us with that language, and
Sure.
especially to Senator Perkins Quok, and we'll
Absolutely.
see if we can work with Director Lippman on that and get things,
Great.
something that works for everybody.
Great.
Further
Thank you.
questions from the committee? Seeing none, thank
Thank
you.
you very much.
Brody Deshays. Brody here? Ah, there he is.
Thank you, Mr. Chairman, and thank you to the committee for hearing my testimony today. I have one copy written to make it easier for the public record, but I want to thank you again. My name is Brody Deshays. I represent New Hampshire Hunger Solutions. I'm testifying in support of Senate Bill 337, which, as you know, would establish a voluntary certification process for doula and lactation service providers. Some of this testimony today was written by our child nutrition manager, who specializes working with school districts and with different providers and healthcare facilities to help deliver some of the best healthcare and children's feeding services throughout the state. So breastfeeding is the most natural way to feed babies, yet many women fall off without support. 83.2% of women initiate breastfeeding, while only 24.9% are still exclusively breastfeeding at 6 months. The numbers are far worse when it comes to racial ethnicity, with more white infants solely breastfed in comparison to Black and Hispanic infants. The American Academy of Pediatrics recommends feeding infants up to 6 months of age to see positive health outcomes. Doula and lactation services are essential to reaching health outcomes and decreasing racial disparities. For many women, the only breastfeeding support they receive is the first days spent in the hospital. The first month of breastfeeding is critical in establishing a solid breast milk supply, and without continued support, many women have to resort to supplementing with formula. Women of low income often don't have a solid support system at home to confide in for help with common breastfeeding issues or support during pregnancy. Numerous studies have documented the benefits of having a doula present during labor. A recent Cochrane review titled Continuous Support for Women During Childbirth showed many positive birth outcomes when a doula was present. Other studies have shown that having a doula as a member of the birth team increases the overall cesarean rate by 50%, and length of labor by 25%, the use of Oxycontin by 40%, and requests for epidural by 60%. Lactation support services are expensive too and often require insurance for payment. Doula rates can range from $500 to $2,000 per pregnancy, which many women can't afford on top of regular prenatal care. There are many benefits to having Medicaid cover doula services. For example, the unique training requirements for doulas hold accountability specific to who will work with Medicaid population. Additionally, people with lower incomes can access services and reduce health disparities. This legislation ultimately is just going to help more mothers access to breastfeeding resources that they and their families and their children need. Thank you.
Thank you for your testimony. Any questions? Seeing none, we appreciate you coming in today.
Thank you for having me.
Brianna Henkel, do I have that right? Yeah. All right. I'm doing pretty good today on the names. It is early.
Have a copy of mine for everyone.
Sure. Well, thanks for coming in. Go ahead when you're ready.
My name is Brianna Hinkle. I am the Legal Policy Fellow at New Futures. I am focusing on maternal health this session. There's not a whole lot for me to add on to what has already been said, but I would like to highlight that behind Mommy Miss was the maternal mortality crisis that the U.S. is facing. This So it's important to get this passed to make sure that Montanus can be fully implemented. Thank you.
Thank you. Questions from the committee? Seeing none. Thank you. All right, last on my sheet is Director Courtney. I left till the end on this one.
Thank you, Mr. Chair, members of the committee. Lindsay Courtney, Executive Director, OPLC. The office is not taking a position on this, and I don't really have much to add. I wanted to make myself available for questions. The only thing that I would note is that we did provide some technical assistance last session on the omnibus bill, and our goal is, if this is truly supposed to be voluntary certification, and if there are other private bodies that that essentially vet applicants, that if we could essentially make it a registration process in the state and utilize those private certifications as a mechanism for ascertaining whether somebody's qualified, that would represent the least restrictive mechanism for obtaining a license, and we would be supportive of that regardless of the particular entity named in statute or otherwise deferred to in rulemaking. So that was our request, and Senator Whitley had honored that at the time, but we'd be happy to work with anybody on some amended language.
Excellent. Well, we'll keep you in the loop with Senator Perkins Cloaker and Henry and myself, and we'll certainly value your input.
Thank you. Appreciate it.
Questions from the committee?
Wonderful.
Seeing none. Thank you. Is there anybody else that would like to testify on Senate Bill 337? Seeing none, we will close the hearing. We're going to, yep, we'll go right on to 487.
Okay. This one's going to take a little while, just so you know.
That's fine. Probably. It'll turn out. All right, we will, Senator Carson is ready. We will open the hearing on Senate Bill 487. Senator Carson, when you're ready.
Thank you very much, Mr. Chair. Again, for the record, my name is Sharon Carson. I have the pleasure of representing Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. Mr. Chair, I was approached by a member of the Personnel Administrative Board. So this bill is really a request from the Department of Administrative Services. So just to talk about a couple things here, the Personnel Appeals Board hears appeals from state employees who believe an application of the New Hampshire personnel rules has been wrongfully taken against them. Most often these cases are appeals of disciplinary actions such as letters of warning or termination from state employment. Currently, the PAB, or the Personnel Appeal Board, is administratively attached to the Division of Personnel within Administrative Services. It shares administrative staff who are employed and supervised by the Division of Personnel. The PAB operating expenses are managed by the Division of Personnel. At times, the administrative attachment with the Division of Personnel can cause a conflict of interest in managing PAB operations, but more importantly, on decisions the board makes in appeals of employees. All cases question the decisions made by their direct employers and ultimately the Division of Personnel. It is not uncommon for the director of the Division of Personnel or even the commissioner of the Department of Administrative Service to be mentioned in disciplinary documents that come before the board. This means that the Director of Personnel or the Commissioner of the Department of Administrative Services could be witnesses before the board. Given their role in administrating the board's budget and staff, the potential conflict of interest is quite apparent. SB 487 dissolves the existing administrative attachment to the Division of Personnel and reorganizes the Personnel Appeal Board as an entity fully independent from the Division of Personnel as well as other state agencies. SB 487 does have a fiscal impact of approximately $253,000 in '25 and $315,000 in '26. It establishes funds for basic operating expenses, part-time staffing, office space, equipment, and supplies. Mr. Chair, at this point, I'm going to conclude my testimony on the bill. There are individuals that are here that are going to be able to answer any questions that you have pertaining to this bill. There are some issues that have arisen, and so I just would like to let everybody know that there's probably going to be a little work needed to be done on this, and I'll be more than willing to do that. So thank you very much,
Thank you,
Mr.
Senator.
Chair.
Any questions? All right. So we have some opposed and some support, so I think we're going to kind of mix them as we go to keep it balanced here. Mark Baudoin.
Good afternoon, Mr. Chairman and members of the committee. In order to expedite, I'm going to try to keep my comments brief, but I'd also...
Chairman, if I might, Mark and I work in the same firm. We're representing two different clients, but is it okay if we testify together?
What's your name?
My name is John Krupski.
Okay, yep, sure, come in.
And that's what I was just about to ask.
Yep,
He
that's
beat me
fine.
to it.
Well, welcome to you both.
Thank you. I'm Mark Bodwin.
And my name is John Krupski, Krupski.
And Bodwin is Beaudouin.
I was close, I had Baudoin.
Nice French name.
All right, please continue.
So this bill came to our attention, and one of the concerns we have on it is it's pretty lengthy. It's repealing a lot of current statutes, and it's trying to put it all under one new statute. One of our main concerns are, some of the unintended consequences. We are going to need to look further through this and go line for line to make sure that none of those unintended consequences come to fruition. And I was happy to hear that Senator Carson said she was willing to work on this bill. We're not specifically opposed to this bill. It's just we have some concerns with some of the omissions in the bill and maybe some additions that would be helpful as well too. And just to make this brief, I'm just going to note a couple of the omissions that we found that were somewhat concerning. In the bill, there's one section under 273D, which references Personnel Rule PER 207-12. It's almost the same language. And if you look at the Personnel Rule, it has 4 criteria for which an employee must meet, one of them in order to have a decision overturned. This bill omits that last one, which reads that the disciplinary action was unjust in light of the facts and evidence. This is important because the PAB is a neutral and detached board from the actual employers. And a lot of times, as human beings are, we may not agree with our employers and have disagreements, and sometimes, emotions get in those ways and decisions are made that may be unjust in light of the facts of the case. And this would take away the power of the PAB to overturn an appointing authority's decision and say, well, hang on, we think this is a little too harsh of a discipline. We think this is more appropriate and reinstate that employee. So that's just one of the concerns that we noted that was left out of the bill. There's the other thing that was a concern to us is that this would repeal the RSA 21-I:58, which provides that the board with equitable authority to modify discipline or decisions of the appointing authority. This
Say that RSA again real quick.
21-I:58.
Thank you.
And this proposed bill would remove the PAB's equitable authority, which provides checks and balances against the authority of the agency, the appointing authority. And again, this is important because it allows the PAB to modify discipline, saying if they felt the suspension was too harsh of a discipline, they could modify it to a written warning. Same thing with like a termination. If they felt that the termination was too harsh of a discipline, they could modify that down to a suspension or a written warning or whatever they felt was appropriate. So by removing that, you're limiting the PAB's authority that they currently have. One other thing that I noted that's not a major issue, but something that I'd like to point out too, is that in the bill, it increases the issuance of the final decision from 40, which is currently 45 days, to 60 days. Not a huge issue, but I can tell you if you're the subject of a person, of a situation where you've been terminated or disciplined, yeah, every day counts. And I've seen a lot of clients, struggle during this period where they're unemployed now and they're trying to clear their name and get back to work. I've represented several clients. Attorney Krupski has also represented several clients in this area. And so I think with some of those issues, one of the things I think that would be important to look at, and this was in SB 75, which was a very similar bill that was just sent to interim study. One of the things that was brought up there was adding a just cause standard for the discipline of employees, as well as it would shift the burden from the appellant to the state to prove the case. Currently in our legal justice system, you have the concept of you're innocent until proven guilty. And the way the PAB is set up right now and the personnel rules are set up right now, you're guilty until you're proven innocent. So you're automatically guilty in there, and you have to try to prove your innocence. And we think it should be the reversed way around. So I think there's a couple tweaks that could be made. And like I said, we're not opposed to the general idea of what the bill is looking to do. We would just like the opportunity to be able to work with the sponsors to maybe come up with some compromise that will work for everybody.
And I reiterate what Mark has stated, but I would also add that putting a just cause standard, in the future in this legislation would put state police officers on equal footing with local police officers and county police officers who currently enjoy a just cause standard, which allows them, they cannot be terminated or disciplined without a just cause, putting the burden on the employer instead of the employee. And so I think in times of retention and attraction, when you take rights away or rights aren't available, some other jurisdictions look more attractive. So I think it would be a good retention and attraction aspect if it were to be considered by this committee.
And just to add that protection for locals and county employees, police officers, I believe it's RSA 41:48,
and also contained mostly in collective bargaining agreements throughout the state under 273A.
And with that, we're happy to take any questions that you may have.
All right. Questions? Senator Perkins-Cook.
You may not have this, and this may be a question better directed for the State Employees Union, but I know we made similar changes to SB 75 to make sure we were shifting the burden of proof to the employer in disciplinary cases, and I just don't have that in front of me, and so I wondered if you guys were aware of how they overlapped or wanted to speak to that, or if we all need to go research that.
No, and we'd be happy to work with Senator Carson in terms of talking of some of those issues. But yes, there was some overlap in regards to the Senate Bill 75, which I believe has been put into interim study for now.
Okay.
Senator Carson.
Thank you, Mr. Chair. As you know, we had a session before this. The Senate Bill 75 was interim study with the intent of taking the language that was worked on and moving it into this bill.
Right.
So you have a more comprehensive statute instead of having pieces here and there. So the intent is, I know that this needs some work, and once we get to work, we're going to include the language of Senate Bill 75 and put it into it.
Thank you.
Further questions? Seeing none, thank you, gentlemen.
Thank you.
Appreciate it.
Good afternoon.
You as well. Attorney Charles Russell.
Good afternoon, Attorney Charles Russell Concord. I'm the rookie on the Personnel Appeals Board, and everyone else seems very busy, so Attorney Russell Concord, I'm the rookie on the Personnel Appeals Board. Basically, I've been on it, this is my 6th month. There's an annual report that comes out, but I want to thank Senator Carson for sponsoring the bill. Basically, we hear appeals from state employees. We hear about 25 cases a year. I looked at the annual report, and that's pretty much what it's been over the last 10 years. As the prior speaker said, it involves disciplinary proceedings. Basically, we're looking, the original intent of the bill was, I guess, was to just continue on what was in effect, but to codify it, to put it together in a one section. I didn't know if there was any intent to make some of the changes that were discussed, and certainly it sounds like the bill needs some work, but it's modeled, the bill is modeled after the Public Employees Labor Relations Board, which hears appeals from potential employment contract violations at all level, local and state governments, and that's an independent agency. As Senator Carson said, it hasn't occurred to me yet on the board, but the commissioner, as well as the of Ad Services, as well as the commissioner of personnel, apparently have appeared as witnesses, and so, you know, and to the appearance of impropriety, here we are under that agency and making independent decisions. So I think that's a good reason to do that. The hearings run usually less than a day. We try to move them on, although we have had multiple day cases. And then the budget includes an office. I think some of those, and then personnel, some of those expenses are probably already within the personnel budget as well and would be deferred out. But I was on the Board of Claims for years, which was independent, 541B, and we had one contact with the Secretary of State's office. So that's kind of what we're looking for here. So if there's any questions, I can answer them.
Thank you. Questions from the committee?
Thank you very much.
Seeing none, we're letting you off easy today. All right, last but not least, Charlie Ellinghouse. I figured I'd save you to last.
Very nice of you.
This must be Matt.
I'm Charlie Arlinghouse. I'm the Commissioner of Administrative Services, and with me is Matt Mavergeorge, who's an attorney, so if anything gets hard, he can answer questions, which I anticipate. The impetus for this bill and for Senate Bill 75, which this is obviously a continuation of, is the Personnel Appeals Board and the relationship with the Division of Personnel and Admin Services. And I know it sounds weird that there's an adjudicative body ensconced within an agency inside state government, and it's bizarre how that could possibly have happened. And I know that's what you're thinking to yourself, and you're wondering, perhaps Charlie knows the history of why that happened. Fortunately, I do. In the 60s and 70s, in the era when state government was a series of disparate agencies all hodgepodged around and not amalgamated at all together, there was a personnel commission. There was actually the director of personnel, or executive director of the commission, as they called him, was the employee in state government who could not under any circumstances be fired, which is a great job if you can get it. At some point when they were creating agencies, and we create DOT and DRA and all sorts of agencies in state government, admin services is created out of a bunch of, admin and control was the basis, and they lump in CDP and a couple of other things. And one of them was the Personnel Commission. Well, at the time, the commission had a board. There was an executive director and a staff, which became the Division of Personnel. And there was a board appointed by the governor, because it was an era where the governor had very little direct control, but he appointed lots of boards. And so there was a board, and they thought we need something for the board to do. And one of the things the board had done in the past was serve as, anytime that guy who couldn't be fired, whose name was Roy something, I don't remember it, but made a decision you didn't like, you could appeal to them. Although given that they appointed him, they probably went along with him. So they created that. We've sort of muddled along like this for decades, and there's this weird thing. And if you ask any director of personnel, so when I started it was Sarah Willingham, who a lot of you will remember, one of the things they would say is, yeah, the PAB is kind of weird. We're sort of the boss of them, but we're not really, and we can't pretend we're the boss of them. People ask us about appointments, and we studiously avoid recommending people for appointment to the board because we have to appear before them. We're usually one side, at least on some level, we're one side. And I have testified before the board numerous times, which is always a little weird, right? But, so since Jason became chairman of the board, we had a lot of talk about exactly how everything is arranged. People will know that 4 or 5 years ago, maybe 6 at this point, maybe in the 2019 budget, there was a bill to change the compensation of the board because we had for decades had sort of an impossibility getting anyone to agree to do it because it's a lot of work and it's a lot of responsibility, and we gave them $50 a day or whatever it was back then. And now there's a regular stipend. I think it's actually the best paid adjudicative board in state government, which doesn't mean it's well paid. It just means it's the best paid in state government, which is a relative term. They've always borrowed staff and borrowed space from us, although not exactly. The hearings are held just wherever we can find a place. And they use some staff time that we provide them, although it can't be anybody senior, because that's what the law currently says. It has to be somebody who's not in a position of authority to do some things for them, which is just a weird situation. We control their budget. Technically, the director of personnel signs their reimbursement forms and everything else, which is also weird. I'm not your boss, but I'm going to sign your paycheck. And so the impetus for this is just to create this. They are an independent agency. They're not, there's some administrative attachment in the sense that independent agencies are administratively attached to agencies for the purpose of budget and HR and things like that. We actually have 5 agencies administratively attached to us. And this would be like that, but we would make clear they're independent. They can hire their own staff. It's not Lori Rudis hiring their staff. They hire their own staff and do all of that. The rules that our attorney friends spoke to, we can talk about. And I don't know that we're ready to talk about all of that today. We worked with DOJ on language and the standards and all of that to come up with specific language. And happy to look at the things they're talking about and sort of investigate them. The main point of this, though, is to make clear that there is an adjudicative body that does not report to me and reports to itself and is an independent body and create a real sense of independence, which I think is important. You know, we don't have the judicial branch report to the governor, for example. So, any questions? Happy to answer.
Questions from the committee? I appreciate the history because I'm always interested in learning how these things occur. It's fascinating.
Thank you.
No questions? I think we're going to let you off easy. I'm certain there'll be more that will come along. But
We're just across the street.
all right. Well, thank you for coming in. Anybody else that would like to testify on Senate Bill 487? Seeing none, I'm going to close the hearing. All right, we're going to open the hearing on Senate Bill 480, and I recognize Senator Carson to introduce the bill.
Thank you again, Mr. Chairman. Just for the record, my name is Sharon Carson, and I represent Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And I have for your consideration this afternoon Senate Bill 480, relative to the administration of professional licensure and certification and the regulation of real estate practice. This legislation is an attempt to clarify certain practices and procedures which apply specifically and exclusively to the regulation of real estate licenses, with exception, which is in section 1 of the bill, with one exception, which is in section 1 of the bill. That section requires of the OPLC that any board or commission whose total number of active licenses exceeds 7,000 must have a dedicated customer service administrator who is trained and possesses specific knowledge of that board's licensing rules, as well as require that such a board have unique public-facing phone number and email address to respond to inquiries from the public and licensees. The intent is to ensure licensees have reasonable access to those professionals at OLPC who are regulating their licensing. Section 2 is designed to clarify how OPLC enforces provisions from a 2018 bill that is related to continuing education requirements for those real estate licensees renewing that license for the first time. This bill adds a definition of post-licensing. The term post-licensing is in rules, but OPLC has felt it is not well defined and therefore are not enforcing that statutory provision. Excuse me. Section 3 reinserts a statute that may have been inadvertently deleted in HB 2 last year. It deals with inactive real estate licenses. Inactive license status is recognized by OPLC, but not defined in either OPLC statute or in the Real Estate Practice Act. Excuse me. This was likely an inadvertent oversight, which this bill rectifies. Section 4 clarifies the statute that the OPLC is able to provide assistance and review applications for continuing education credits and not leave that responsibility solely on the backs of the real estate commissioners. This was an issue that the real estate commissioners had earlier this year, which has been resolved. However, putting it in statute is probably wise. Mr. Chairman, there are leaders from the New Hampshire Association of Realtors who are here, will provide some additional information and can answer any questions that you might have. The realtors did provide the OPLC with the language of the bill last fall and did get some feedback. There might not be an agreement on all elements of the bill, but they're ready to work with OPLC to resolve any questions or concerns. Thank you very much, Mr. Chairman, and I am going to conclude my testimony because the experts are here and can answer your questions.
All right, thank you, Senator Carson.
Thank you very much.
Chris Norman and Bob Quinn from the Realtors. Do you want to come up together? Yeah. Okay. Come on.
I am Bob Quinn, CEO of the New Hampshire Association of Realtors.
Mr. Chair, members of the committee, my name is Chris Norwood. I am the 2024 Chair of the New Hampshire Association of Realtors Public Policy Committee.
And just to give you a little background and where the impetus for the bill came from, last spring, it was May of 2023, the OPLC sent out some messaging to licensees indicating that certain statutory, I'll call it interpretations, were perhaps not being done properly by previous administrations, and therefore they were clarifying how they were going to enforce them. We had, at that point, engaged in a discussion with OPLC. Some of those concerns were rectified. Others you'll see here in this bill. And I'm going to turn it over to Chris, and he'll take you through the first two elements of the legislation.
So the first section here, new paragraph starting on line 1. This is the 7,000 member threshold. I've been a licensee for 20 some odd years now, and when OPLC and all of the boards merged, some of our members found that the customer service side was challenging, in that finding a dedicated individual who was fluent in our case real estate issues was difficult. And this would say, hey, if you have over 7,000 licensees in any board, I think it's appropriate to have someone dedicated because there's the sheer number of activity that's taking place. We admit 7,000 is somewhat of an arbitrary number. Real estate licensees are in excess of 10,000, but we do think that there are other boards that would benefit from having a dedicated individual to answer industry-specific questions that arise from time to time. The second portion, which begins on line 12, is the post-licensing requirement. So back in 2018, Senator Carson sponsored a bill SB 461, which said new licensees are required to take a certain type of course in their first 2 years of service. So in the real estate world, every 2 years we have to get relicensed, and this says simply that those new licensees would have had to have taken those specific 12 hours of credits that would, further enhance their knowledge of the industry that may be different than someone who's a little bit more seasoned. As Bob said, that there was a differing opinion on the interpretation of the statute, and we wanted to put this, clarify this in the RSAs, that there would be a definition of, I'm just going to say it was post-licensing requirements. So that's what that section refers to. And I'll turn it to Bob to talk about sections 3 on line 20.
So as Senator Carson pointed out, Section 3, we think, was inadvertently deleted in House Bill 2 last year. There were dozens of statutory requirements, certainly not just specific to the real estate industry, that were deleted, and authority was moved to RSA 310. I think this was an inadvertent deletion. Real estate licensing may be a little bit different. I certainly don't know the other occupations, their requirements, but in real estate, you can have your license go into an inactive status. This paragraph sort of defines what an inactive status is. It also, very importantly, if you do move into an inactive status, you are still authorized to accept any compensation or referral fees that you may have earned while you were inactive with your previous broker. So that whole language has been removed. And I'll let, I know Director Courtney can add anything, but I think we're both in agreement that that was inadvertent, even though I think she probably would like to see the language of this potentially changed a little bit. And then the final section, section 4, is sort of just technical, but right now when a instructor for a continuing education course puts in for approval, they need to be approved both as an instructor in one application and then their course in a second application. What we hope to have happen here is that application just be a singular application, so you don't have to duplicate efforts, make it a little bit easier and streamline the process. And that's certainly something that had happened previously, and it worked well. So in a nutshell, that's kind of the bill. I will also point out that we have had very positive, productive conversations with the OPLC over the past couple of months, as well as members of the Real Estate Commission. So we are certainly open to and want to continue that discussion to ensure that this works for both the licensees as well as for OPLC.
Thank you. Questions from the committee? See none? I guess we're letting everybody off.
Thank you very much.
Thank you very much. Thanks for coming in. Simon Thompson. Is Simon here? Oh, there he is, right behind. I see him now. Welcome.
Good afternoon, Mr. Chairman, members of the Senate ED&A Committee, and Happy New Year. Senate Bill 480, I should say Simon Thompson, Sheehan Finney Capital Group, here on behalf of Steve Rancourt from the Electrical Contractors Business Association. Typical to a tradesman, he needed to get to a job before the end of the day, so he asked me to say just one point on this bill, and it's to support Section 1. Obviously, we're not concerned about the real estate things, but you know, Steve and others have come before you and the House Committee oftentimes about the customer service at OPLC, so this effort at adding a dedicated staff person is very much appreciated, and he wanted me to pass that along. The one question he had that he would have asked if he had been here was, there is no fiscal note on this bill, wasn't able to be prepared in time. Curious if the additional dedicated staff person would be somebody already on staff and would be repurposed or retrained to do this, or if it will require additional staff people, because one of the only other things that licensees care about a lot than customer service is their fee, their license fee. So that was just one item he asked me to bring to the attention of the committee. I don't expect perhaps an answer right this second, but did want me to kind of go on the record with that question.
So the fiscal note that I have is showing about $540,000 in expenditures in 25, 558 and 26, and 576 and 27.
Okay, I guess.
So there is a fiscal note out, and the methodology kind of explains it.
Okay, I do not have that here, so
All right.
I'll take a look at that.
So it is available, and if you can't find it, let me know, and we'll make sure you get a copy.
I know how to reach you.
All right.
All right.
Questions from the committee? Seeing none. Thank you.
Thank you.
Appreciate it. Director Courtney. I left you to last so you could know what all the concerns were.
I appreciate it. Thank you again, Mr. Chair, members of the committee. Lindsay Courtney, Executive Director, OPLC. So I echo the comments from our friends at the Realtors Association. We've had very productive, positive conversations about many things, and I think the one thing that I wanted to emphasize is that we at OPLC understand the issues that were the genesis of this bill, and we're committed to addressing them. I'm not positive that the legislation as written is actually going to address the issues, and so I would welcome the opportunity and some additional time to talk through those issues. I did speak with the chair of the commission this morning, and there are some other things that maybe we could address with this piece of legislation. It sounds like all parties are interested in further conversation, and we would also support that. But I did want to take the opportunity to mention a few things. The first being with the Section 1 issue regarding an additional customer service representative. So to be clear, I think that our wait times are not ideal. The average wait time for a Tier 1 phone call is about 4 minutes, but it can be, depending on the time of day, upwards of 20, 25 minutes, which is an issue I think that needs to be addressed. We have some solutions in the works, but obviously that takes time and obviously money to accomplish those things. But the customer service that we do provide is excellent. Based on voluntary surveys, we're at a 5 out of 5 rating. So I know that there have been some grumblings about customer service. I think the real issue is just the time it takes to get to a phone call, and we're committed to addressing that. In terms of adding additional staff, we could certainly do that. We would need appropriations, which is not provided in this bill, as well as establishing additional positions, which is not provided in this bill. The bill just requires that we provide people, but we would actually have to shift existing jobs, move work away from the people that they're doing that work onto other people to free up people. I'm not sure that that's the best way to accomplish it. But again, we can talk to our partners at the association further about that. The second issue regarding inactive licensure status, I would agree that it was a completely inadvertent mix, and I would thank Mr. Quinn for bringing it to my attention. With all of the repeals in HB2 and a little bit of the delay in updating the AgenCourt website, he was the first person to bring it to my attention. So we don't have any issue with bringing the language back. I think that in talking to the commission or the chair of the commission, that we may want to have some additional conversations about what that looks like. There are basically two methods or mechanisms for inactive status. One is one that you have to renew and meet continuing obligations, is considered a license, allows you to receive compensation. Then there's the other kind that's essentially not a license. It depends. Different boards use different mechanisms, and I think that the commission wanted to have that conversation and be thoughtful about the language if we have the time to do that. The last part regarding the continuing education issue. So this came about because the historic practice, the statute requires currently both approval of instructors and approval of courses, but historically the practice had been conflated, and in my opinion improperly so. And so as we started to enforce the requirements, it became clear that maybe this is not the process and that the collective we wants to use. I think the commission is interested in maybe removing the requirement that instructors be accredited, and I think that we would welcome this as an opportunity to have that discussion and maybe make that change, which I think would achieve the same results that the association is trying to achieve. So with that, I'm happy to answer any questions. I think bottom line is we support the objectives. I think the means for achieving those, I think, require further discussion, and we're willing to collaborate with stakeholders to get it done.
Thank you for your testimony. Questions from the committee? Excuse me, Senator Altshuler.
Thank you, Mr. Chair. Thank you, Director Courtney. You were just saying that as far as personnel goes, so this says is that that you have asked for 2 senior board administrators to serve 2 of the larger boards, and then hire 6 more senior board administrators. Are you reevaluating that, or did I not understand?
No, so there are currently 6 boards that have over 7,000 licensees, and I think the intent is to have an additional staff member to assist those boards. We would need both appropriations and the establishment of that position. Unlike other state agencies, OPLC is young and we don't have a lot of positions that are unfunded. The other thing that I wanted to mention is we do have dedicated people. We have 4 dedicated licensing, well, 1 licensing supervisor and 3 licensing reps. The issue that I think that brought this forward is how long it takes to get to that tier 2. So you call in, you get a tier 1. Most of our questions relate to, what's my registration code? What's my renewal time frame? But the people who really need assistance need to get to that tier 2. And I think it's that time frame to getting to that tier 2. So we do have dedicated support people, but it sounds like maybe the interest is in reducing that time frame, which it's a shared objective.
Okay, are there any further questions from the committee? Senator Perkins-Coker.
Yeah, thank you, Director, for being here. So you mentioned, I think at the end of your remarks, potentially not, I think, having instructors for continuing education accredited. I guess help me understand a little bit, because in my mind, what OPLC would be doing is sort of like allowing, the Real Estate Commission to sort of create its own rules about how it oversees its practitioners and licensing. For example, I'm a lawyer, the New Hampshire Bar Association sets my rules, So I guess just kind of help me understand why that question would rise to the level of what we're addressing in statute.
Well, because I think when OPLC started enforcing the requirement that's in the board rules that the instructors be separately licensed or certified, that brought up issues of the different application. For example, the Administrative Procedures Act defines license to basically be anything that requires agency approval, which would be accreditation of instructors. Federal and state law requires that if you get a license, you have to fill out a form that includes your social security number. And so there are all these extra requirements that they're not used to having to satisfy. And many continuing education instructors are not licensees. They may be experts in the field of mortgage brokerage or something like that. And they're not motivated to obtain a license and provide all this information when their course is also getting approved. So I think the commission, and the OPLC is not taking a position, but the commission is interested in thinking about whether they truly need to license separately the instructors. And if they decide that they don't, there's no need for legislation requiring a single application for both instructors and courses.
Got it. Thank you. That was very helpful.
Further questions? Seeing none, thank you.
Thank you for your time.
Is there anybody else that would like to testify on Senate Bill 480? Seeing none, we'll close the hearing. Up next will be Senate Bill 478.
Okay, here we go.
I think that went back. Which one are you missing?
87, 47.
Yeah, I did. Thank you, sir. I'm trying to keep everything organized. right, we'll open the hearing on Senate Bill 478, and I'll recognize Senator Carson.
Thank you again very much, Mr. Chairman. For the record, my name is Sharon Carson. I represent Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And I have for your consideration today Senate Bill 478 FN relative to child daycare, residential care, and child placing agency licensing. It's important to let you know that this bill was at the request of the Department of Health and Human Services. What it does do is, one, it is consistent with existing department administrative remedies for licensed daycare agencies and recreation camps. The proposed legislation also includes licensed residential care and child placing agencies also being subjected to administrative fines for non-compliance with the provisions of its specific licensing division, RSA 170E:24. 2, it eliminates the issuance of child care employment eligibility cards currently required for licensed child care agencies under RSA 170E:7, Section 4A, and licensed residential care and child placing agencies under RSA 170E:29-A, Section 7. This requirement is no longer necessary where staff eligibility information is readily available to employers via the New Hampshire Connections Information System portal. 3, it eliminates the requirements in RSA 170E:10, which is the child daycare licensure, and RSA 170E:33, residential care and child placing licensure, that the department shall give notice to the health officer and fire department of the town or city in which the licensee is located, stating the granting of such license and its terms. Notwithstanding, local officials are directly included and involved in the initial licensure application process, and the results of license issuance is publicly available online via the department's website. Thus, this provision of law has become unnecessary, yet remains an additional resource demand on the department. And finally, 4, it amends 170E:31 to align specialized care licensing from a 2-year to 3-year licensure cycle, consistent with other entities licensed by the department's child care licensing unit. Thank you very much for your consideration. There are folks here from the Department of Health and Human Services to discuss this issue with you, and I appreciate your time, Mr. Chair, and I would appreciate just, if you have questions, they're going to come up and speak. So,
Thank you, Senator.
thank you very much, Mr. Chair.
Melissa Clement and Doreen, if you want to come up too, you can. It says if needed, so I'll leave that up to you guys if it's needed. If you'd like to come up together, there you go. Good afternoon, welcome.
Good afternoon, thank you, Mr. Chair. Members of the committee, we're just here to answer any questions that you may have on the legislation and to explain it further as needed. I'm Melissa Clement, Chief of the Child Care Licensing Unit.
Good afternoon, it's nice to be here. I am Doreen Shockley, the manager of the Bureau of Licensing and Certification at the department.
All right. Well, I guess, are there questions from the committee? I know I'm trying to get my head around on exactly what we're doing, but I don't know that I have any specific questions myself right this minute. Senator Perkins-Coker.
Yeah, thank you. I feel similarly. I may have more questions later. You know, it appears to me from Senator Carson's description and just from reading this that it's largely a cleanup bill. I guess I just wanted to ask a little bit about the new section, the enforcement section in 8, which appears on page 3. So I guess what was in place previously, or not in place, that's raising the need to sort of find these childcare facilities, and perhaps you could just give us like an example, an anonymous example. And nice to see you guys.
Yes,
Thank
nice
you.
to see you. Thank you, Senator Coca, for your question. Perkins-Coca, sorry.
That's okay.
And essentially, we are putting this in place because Currently, for our residential childcare programs, we would, if we have citations, we issue them, they provide corrective action plans. Our next step, if there's continued noncompliance, we would move to directed corrective action plans from the department that they need to follow. And then after that, we only have the provision to either suspend or revoke their license. There isn't an in-between that we have for other agencies that are licensed by the department. We do have the ability to find childcare programs, and it's not something we take lightly. It's not something we do regularly.
Right.
We don't issue a lot of these, but we're just finding the need to have something that's in between so we can continue to work with the program so they can come into compliance, because we don't want to revoke licenses. We want to be able to have them compliant and so that they're providing safe places for children.
Okay, that's super helpful. Just one follow-up, if I may, Chair? Yeah, and just if you could just give sort of an example, of what kind of violation could create a corrective action plan, and would all violations follow that same pathway you just described?
So anytime there's non-compliance with a rule, we require a corrective action plan. So that's like the first step. We go out, we find that there's noncompliance, they provide that. If we find on follow-up visits that there's continued noncompliance, or we receive complaints, we do investigations, that's when we figure out what the next step is. And most of the times the next step, we would do a directive plan of correction because maybe what they did previously wasn't working, so we found something else they needed to do. And it's always a progression. Unless a child's safety is like imminently at risk and we don't feel children are safe there, then we would move to a revocation immediately. But we just want the ability to work with programs a little bit longer. And I don't know if Doreen has.
Yes, thank you, Melissa. I'd like to add to that a little bit more, to the extent that when we go out, if we identify non-compliance, as Melissa said, we issue a statement of findings, then we get a corrective action plan. If on a monitoring visit or a follow-up visit, we identify the same non-compliance, that's where we would then issue a directed corrective action plan, because the program submitted a corrective action plan. We accepted that corrective action plan only to discover that that wasn't followed. So the next step would be a directed. Then if it continues, then we would generally issue a warning, not the fine, but a warning. This happens in our non-residential childcare license programs already, as well as our adult license programs. But I just want to make sure it isn't, if we go out and we see that, a program is out of ratio, and then we go out and we find that there's some other non-compliance, that's not the progressive. It's when the same deficiency is cited over and over. We generally, and again, revocation, the department takes any administrative action we take very seriously. It's not something we want to do, but we have the flexibility. We meet with programs. We have meetings in person where I'm part of those meetings. We try to work with people. In the way the legislation currently is, there's not a lot of flexibility, and there's not a lot of opportunity for us to work collaboratively with the programs to help them come into compliance. It's a directed plan of correction and then revocation, and that just doesn't seem the way that we would want that.
Sure. I'm sorry, Chair, one more follow-up.
Go ahead.
Just generally speaking, what, and I'm sure this varies widely, but just so that we have an idea, and I see there's rulemaking in here, but what kind of time frames do these processes generally play out over?
So that would depend on the program. I can speak to programs where we go out, and the other thing about a fine too is I think sometimes, and again, we give warnings before we give a fine. So the process is, we cited you on January 1st for noncompliance with XYZ. In March, we received a complaint, discovered that you were still non-compliant after you submitted your plan of correction. So now we're going to tell you this is what you need to do to come into compliance. So then we go back out, and then it's non-compliant again. And again, depending on the egregiousness, if a child is at imminent risk, we're not going to draw this out. This is administrative error, things that don't impact the health and safety of our children, right? So, but this can take, it can take a year.
Yeah.
In some cases. In some cases, we work with programs for over a year or 18 months to 2 years. This is, This is a process to help programs come into compliance without having to revoke a license. But again, I do think it's important, and I'm glad Melissa stressed it. If children are at risk, that's a completely different avenue that we're not talking about. This is to try to help people come into compliance.
Okay, thank you very much. Thank you.
Senator Altshuler.
Thank you, Mr. Chair, and thank you. I may have missed this in Senator Carson's presentation, but on page 2, the crossing out of lines 16 through 19 is the notification to the town somewhere else in the statute that I'm missing?
So the town, we cannot issue a license at the department unless the towns have also granted approval. So the towns are they've already done their inspection. That comes first. We're just actually creating the document and sending it to them once we have the approvals in place. Sure.
Further questions? Seeing none, thank you.
Thank you very much.
Jackie Cowell. Good afternoon and welcome.
Good afternoon. How do you do?
Doing well, thank you. Could you turn your mic? Oh.
I saw a light on it, so it needed to be read. How do you do? I'm Jackie Cowell from Early Learning New Hampshire. We're a statewide nonprofit, and we're an association. We represent childcare. We do advocacy for childcare, both for their programs, the businesses, but also the families they serve. And we also do some public awareness raising about the importance of the early years. And we also, like I said, we're an association, have members. And so I'd just like to say we do support this bill, and thank you, Senator Carson, for introducing it. We run twice a month a Zoom call with the child care community. We usually have over 100 people on that Zoom call, like I said, twice a month. And we didn't know about this bill the last time we did it. I think if we told them about it, there'd be a lot of hoop hoop hoorays in the Zoom call for no longer having to do that $25 employee card. It had been difficult in many ways and a burden for some and for the child care employers and employees. So we're very happy this bill is here. That's all I had to say.
Thank you. Questions? Seeing none, thank you. Anybody else that would like to testify on Senate Bill 478? All right, seeing none, I am going to close the hearing. Well, that's the last of them that we have for today. So I want to thank the committee for their work. I know this was a little tight coming in right after our Senate session, but I appreciate you all getting here in a timely manner. And we will, we're pretty much going to meet every Wednesday from here on. We have 30 bills assigned to our committee. There'll actually be one more. I had a late filing. Well, I have to go for a late filing because I had a bill that I put into OLS and it didn't get drafted. So that will also be coming. It got missed in the file. Yeah, we'll have 31.
You want to take my 64?
No, I'm good. My plan is to keep approximately 5 or so on each Wednesday so that we are done with all of these bills by February 7th. That is my plan. We may have to alter that a little if the workload gets too heavy and we have some things that need to be done, but most of our bills are fiscal notes, and I want to make sure that I'm getting them out. You'll see the priority is on those so that I can get them out into finance as quickly as possible. No, we'll be at 9 a.m. The only reason we were at 1 today was because we had to wait through session. So we'll be going back to our 9 a.m. Wednesday morning schedule, and my hope is to get through 5 or sometimes 6 each day, and we keep rolling. So if that gets to be too much, then I do have a little bit of room that I could back off a week if I needed to, but I'm hoping to just keep the pedal down and move right through these. And if we've got extra time, I'll give it to you on the other end. That's my plan. So, any questions before I recess for today? We did well. We did very well. So thank you all, and we'll see you next Wednesday.
Thank you.